The subcommittee will come to order, and without objection, the chair is authorized to declare recesses of the subcommittee at any time. Welcome to this afternoon's hearing on the Patent Trial and Appeals Board and the Appointments Clause, implications of recent court decisions. I will now recognize myself for an opening statement. The Leahy-Smith America Invents Act of 2011 was a sea change in patent law. One of the biggest changes was the creation of a new way for the Patent and Trademark Office to reconsider whether it had properly issued a patent called inter partes reviews, or IPRs, before the Patent Trial and Appeal Board, or ptah. Such IPR challenges have become central to the adjudication of patent disputes. There have been almost 10,000 challenges brought since the ptah was created in 2012, with between 100 and 150 new filings each month. The IPR process in its current form has its critics and its defenders, but that is not why we are here today. Rather, we are here today because of a more fundamental issue, whether the ptah as currently configured is constitutional. A recent court decision, Arthrex versus Smith and Nephew, found that it is not, that the administrative patent judges, or IPJs, who comprise the ptah were appointed to their positions in violation of the Constitution's Appointments Clause. The court further concluded that the constitutional violation could be remedied by removing the civil service protections offered to the APJs. According to the court, this makes the APJs clearly inferior officers in line with the way that they are currently appointed. The court stated that it believed Congress would have preferred this approach had it known about the Appointments Clause issue when it passed that American Invents Act. Speaking for myself, I find it inconsistent with the idea of creating an adjudicatory body to have judges who have no job security. It goes against the idea of providing independent, impartial justice if a judge is thinking about his or her livelihood while also weighing the facts of a case. Many Article I judges have fixed-year terms, and Article III judges have life tenure for this reason. I recognize, however, that the Arthrex Court was in a difficult position with limited options after identifying a constitutional defect. But that is why I felt that it is crucial that we have a hearing on this topic immediately, so Congress can be in a position and in possession of the facts and ready to act. We need to learn more about the impact of this decision on existing cases and the likelihood of the decision being upheld or modified by either the in-bank Federal Circuit or the Supreme Court. And most importantly, we need to begin to consider whether Congress must get involved to provide a sensible solution. Frankly, I worry that we cannot trust the courts to fix this. We are living through an era where the Supreme Court is taking increasingly extreme positions about the constitutionality of the administrative structures that have existed since the New Deal. These decisions second-guess the legislative process and the solutions Congress has worked hard to pass in order to handle the realities and complexities of a modern society. Notwithstanding that trend, I believe it is our responsibility to consider a legislative fix to the Appointments Clause problem that preserves both due process and the careful balances struck by the America Invents Act. I'm pleased that we have a panel of legal scholars and distinguished practitioners. Thank you for being here today, and I look forward to your testimony. It is now my pleasure to recognize the ranking member of the subcommittee, the gentle lady from Alabama, Ms. Roby, for her opening statement.
Thank you, Chairman Johnson, and thank you to our panel of distinguished witnesses for being here today, and I apologize for running in. I always like to introduce myself to you prior to the hearing, but I do appreciate your willingness to come here to discuss these really important issues. In reaction to concerns about patent litigation abuse, Congress, of course, passed the America Invents Act in 2011. This legislation created new proceedings within the Patent Office to allow companies threatened with infringement to challenge the validity of patents. These proceedings are, of course, overseen by the Patent Trial and Appeals Board, or the PTAB. The intent behind creating the PTAB was to have a quick and inexpensive alternative to district court litigation. The PTAB has been very effective at invalidating patents and saving companies accused of patent infringement from expense and burdens of a lengthy district court case. With that success, detractors have argued that PTAB rules strongly favor challengers. Some inventors argue that because the PTAB applies lower court standards, the PTAB can be manipulated into invalidating valid patents it should not. Because patents are so important to inventors and to companies, it is important that the PTAB properly balance competing interests to fairly and properly determine a patent's validity. The Federal Circuit's recent decision in Arthrex, Inc. v. Smith & Nephew, Inc. concludes that the PTAB administrative patent judges, known as APJs, were not constitutionally appointed and that the current structure of the PTAB violates the Appointments Clause. The court reasoned that because APJs exercise significant authority, they are considered principal officers and should be nominated by the President and confirmed by the Senate. The court concluded that the appointment of APJs could be constitutionally remedied by severing provisions within the American Invents Act that provide APJs with Title V protections, making them subject to removal at will of the director. The subsequent decision of the Federal Circuit suggests that the constitutionality of the PTAB is no longer in doubt. However, there are concerns with whether the Federal Circuit fix is constitutionally adequate. Unlike many other agency boards, there's no review of PTAB final decisions within the Patent Office. The only review of these decisions is conducted by Article III courts. Because these decisions are so impactful, sometimes meaning tens or hundreds of millions of dollars, or the viability of a small business, it raises doubts that agency officials who are not Senate confirmed should have so much independent authority. So I really look forward to hearing from you, our expert witnesses, to hear whether the court correctly concluded that PTAB appointments were unconstitutional, that the defect was corrected by making them their service at will, and what, if any, steps Congress should take here. And so with that, Mr. Chairman, I yield back the balance of my time.
I thank the gentlelady, and I'm now pleased to recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, and thank you for holding this important hearing today. I find it remarkable, after the years spent working on the 2011 American Invents Act, which created the Patent Trial and Appeal Board, or PTAB, that the many cases that have gone before the PTAB and then to federal court, and an earlier constitutional challenge to the PTAB that the Supreme Court rejected, that we should now find ourselves here today with the constitutionality of the PTAB structure in question once again. This length of time has allowed PTAB proceedings to become an established part of the patent enforcement landscape. That makes the Arthrex decision, which found that administrative patent judges, or APJs, performed the duties of a principal officer, but were appointed in a manner suitable only for inferior officers, particularly disruptive. While the Arthrex court tried to limit the disruption by providing its own court-ordered fix of removing the civil service protections for APJs, and by articulating which open cases should be entitled still to raise the issue, it is clear that both of these points will be further litigated. In fact, they already have been. The appellant in a case heard after Arthrex, also raising an Appointments Clause challenge, contended that the Arthrex court's remedy of removing civil service protections was not sufficient, and that the PTAB as currently configured should be declared unconstitutional in its entirety. While I take no position on a suitable remedy, I do have concerns with the current so-called remedy of removing APJ's civil service protections. The apparent thinking behind this solution, so-called, to the Appointments Clause problem was that such a change would make APJs clearly subordinate to and incentivized to be aligned with the policy guidance of the only official of the Patent Office who is presidentially appointed and Senate confirmed and is therefore a principal officer, the director. While this may be true, I question whether this is the right way to achieve the apparent objective behind Appointments Clause jurisprudence, namely to ensure that there is an official sufficiently accountable to the President who signs off on important executive branch decisions. I say this because it makes the director's influence on administrative patent judges indirect. The judges are likely to try to discern what the director wants, particularly if a novel question arises and there is no guidance, and litigants will be left wondering if the decision they receive truly represents the impartial weighing of facts and evidence under the law. The extent to which the director's views are incorporated into any decision will not be transparent, and that is generally not consistent with the way that adjudicatory tribunals are structured. It may be that under the Constitution, the director must be entitled to have a level of review or influence over any case finally decided by ptah. But it is not clear that this is the best way of allowing that sort of review to happen. That is why I am grateful that we have with us today experts in patent and administrative law, as well as individuals familiar with the complexities of the ptah and patent litigation more generally. If the court's ability to fix this constitutional defect turns out to be this constrained, I believe it is wise for Congress to begin to think about what we might do in response. I look forward to hearing from our witnesses. Now yield back the balance of my time.
I thank the gentleman, and I will now introduce the witnesses for the first panel. John F. Duffy is the Samuel H. McCoy Professor of Law at the University of Virginia School of Law, where he teaches administrative law and patent law, among other subjects. He was previously a professor at several other law schools, including George Washington University Law School and the New York University School of Law. Mr. Duffy clerked for the Honorable Justice Antonin Scalia and the Honorable Judge Stephen F. Willian of the D.C. Circuit Court of Appeals, and has a BA in physics from Harvard University and a JD from the University of Chicago School of Law. Welcome, sir. Mr. Robert A. Armitage, is a consultant on IP strategy and policy. Previously, he had a long career in the intellectual property departments of two leading life science companies. Mr. Armitage was the past president of the American Intellectual Property Law Association and several other prominent intellectual property organizations. He was a founding member of the Coalition for 21st Century Patent Reform, which was actively involved in the legislative process leading to the passage of the America Invents Act. Mr. Armitage has a BA in physics and mathematics from Albion College, a master's in physics from the University of Michigan, and a JD from the University of Michigan Law School. Welcome today, sir. John M. Whalen is the Intellectual Property Advisory Board Associate Dean for Intellectual Property Law Studies, George Washington Law School, where he oversees and coordinates all aspects of the law school's intellectual property program. He was the Deputy General Counsel for Intellectual Property Law and solicitor at the U.S. Patent and Trademark Office, responsible for all IP litigation involving the agency. Mr. Whalen clerked for the Honorable Randall R. Rader of the Federal Circuit and the Honorable James T. Turner of the Court of Federal Claims, and has a bachelor's degree in electrical engineering from Villanova University, a master's degree in electrical engineering from Drexel University, and a JD from Harvard Law School. Welcome, sir. And last but certainly not least, RTK Rai is the Elvin R. Latty Professor of Law and Faculty Director at the Center for Innovation Policy at Duke University School of Law, and is the recipient of numerous grants to study innovation and technology transfer. She served as the head of the Office of External Affairs at the USPTO. Ms. Rai has taught at several other law schools, including Yale Law School and the University of Pennsylvania Law School, or University of Pennsylvania School of Law. She clerked for the Honorable Judge Marilyn Hall Patel of the Northern District of California, and has a BA in Biochemistry and History from Harvard College and a JD from Harvard Law School. Welcome today. Before proceeding with testimony, I hereby remind the witnesses that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to penalties of perjury pursuant to 18 U.S.C. Section 1001, which may result in the imposition of a fine or imprisonment of up to 5 years or both, should one fall victim to conviction. Please note that your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. And of course, when the light turns to red, it signals that your time has expired. Mr. Duffy, you may begin.
Thank you, Chairman Johnson and Ranking Member Roby, and distinguished members of the subcommittee. I appreciate you inviting me here to appear before you, and I really appreciate you spending time on this important constitutional issue, especially because in light of recent decisions, I think it's fairly clear that the constitutional structure is under a cloud of doubt right now. And I think one of the main goals, as referenced in the opening statements we just heard, is to try to find some sort of clear solution that might cut down on litigation. As things currently stand, I think the judicial branch would be unable to come up with a final resolution until many months, possibly until 2021 or even beyond, given the pace of litigation in the appellate courts. Given that, I think one of the goals here today, as I understand it, should be to try to understand the problem and perhaps look at legislation that could remedy the problem. With that basic introduction, I'll just give a quick summary of the Appointments Clause. The Appointments Clause is something I've written about before. In fact, I wrote an article about 12 years ago called "Are Administrative Patent Judges Unconstitutional?" And the answer then was yes, and the Congress responded to that constitutional problem. I think the hearing today could be entitled, "Are They Unconstitutional Again?" And I think the answer might very well be yes. The Appointments Clause itself, though, is very, very simple. The first basic principle of the Appointments Clause is that all officers who are not elected officials, as you are, have to go through the Appointments Clause if they're exercising any significant authority under the laws of the United States. The Supreme Court established this nearly a half century ago, and I think it's a fundamental cornerstone of the jurisprudence in the area. The second major principle that we have to understand is there's 4 and only 4 ways to appoint people to offices in the United States. It's not an open set of a large number of different appointment mechanisms. There's only 4. And the final principle is that if the Congress wants to use 3 of those appointment mechanisms, and those 3 are the president acting alone without the advice and consent of the Senate, or the courts of law, or head of department, then that officer has to be what the Constitution calls an inferior officer. And that's what we're focused on today. And there is one small point I would have to say, is that both scholarship and judicial statements often counterpoise inferior officer to principal officer. And I've even done that as a shorthand in my own scholarship. I think that we should stick to inferior officer because that's the only word that's used in the Appointments Clause. The word principal officer is used in another place in the Constitution, but I think it has a different meaning there than what the shorthand that it's used in Appointments Clause scholarship and jurisprudence. So I'm going to try my best not to use the word principal officer. I'm going to just talk about whether these judges are inferior officers. There's a long history to this, which is summarized in my written testimony, but to summarize that very quickly is that this did not spring unexpected. There were prior decisions, prior constitutional problems with administrative patent judges, and also prior D.C. Circuit Court rulings on another set of judges who worked in the copyright area that also declared, who were appointed in a similar way, and were declared unconstitutional some years ago, and their tenure protections were severed as a remedy. By the way, that litigation that led to that was actually, or the D.C. Circuit's ruling was the DC Circuit ruling was based on an earlier concurring opinion by then Judge Kavanaugh. So he laid out the constitutional problem in a concurring opinion, and then the DC Circuit, on a unanimous panel of the DC Circuit, later adopted that analysis. I mention that just because I think it gives us one insight into whether any justice might think there's a constitutional problem, and I think the answer is probably yes, given Justice Kavanaugh's early concurring opinion. That's an introduction to the basic constitutional issues. What I think the main goal of this hearing is to try to find solutions, and I've set forth 3 possible solutions. One solution is to simply have Senate confirmation for all the APJs, all 200 and so APJs. I think that's possible. In the past, many officers in the executive branch, hundreds, were confirmed by the Senate in one fell swoop. But I think that might be considered administratively difficult these days. The 2 other remedies, which I think are more in play, is to establish a small number of additional officers in the Patent Office who are confirmed by the Senate, and have those few officers review decisions, or simply to give a clear path of review to the director of the PTO. Those are the solutions that I think are the most obvious ones and that we would spend time on today. Thank you very much.
Thank you. And next we will hear from Mr. Armitage, 5 minutes.
Yes, Chairman Johnson, Chairman Nadler, Ranking Member Roby, Vice Chairman Correa, and other members of the subcommittee, thank you for the opportunity to testify today on issues arising from the recent court decisions as they relate to the constitutionality of the PTAB under the Appointments Clause. The Athena decision addressing this issue, if nothing else, creates an opportunity to look back at how the PTAB was initially conceived and perhaps spur some new thinking on a key issue, specifically whether one administrative board charged with handling both patent and trials and patent appeals should remain in the Patent and Trademark Office. When the PTAB statute was enacted, Congress in large measure accommodated the views of the United States Patent and Trademark Office that the PTAB simply continue with a new name the same statutory provisions that the PTAB's predecessor, the Board of Patent Appeals and Interferences, had had. Otherwise, this new PTAB statute was largely unchanged, except expanding its jurisdiction to include these trials arising from the inter-parties review, which you discussed earlier, and also post-grant review. With the benefit of both hindsight and the Athena decision, I believe there's a different and better way in which Congress could have written the PTAB statute, and one that would have assured better Appointments Clause compliance. First, the old Board of Patent Appeals and Interferences, in spite of its name, was mostly a patent appeals board, one that rarely conducted trials under its jurisdiction over patent interferences. Second, the scope of the new jurisdiction of the Patent Office under the AIA over the validity of issued patents, especially through this second procedure, the post-grant review, was entirely unprecedented in the more than 200-year history of the office. As a result, this new jurisdiction required the office to create an entirely new capability to conduct potentially large numbers of patent validity trials, including in the case of post-grant reviews, trials on patent validity issue, any patent validity issue that a district court judge might hear in a patent infringement action. For these reasons, the AIA might better have created in the Patent Office a patent trial board, specifically charged with conducting these new validity trials and distinct from the old Board of Patent Appeals and Interferences. This would have allowed the Board of Patent Appeals and Interferences to return to being just a patent appeal board. Until 1984, such an appeals-only board existed and heard only ex parte patent appeals from inventors whose claims had been rejected by patent examiners. Moreover, historically, the Patent Office director could exercise plenary control over the decisions on appeals decided by this pre-1984 Board of Patent Appeals. The AIA might have specifically reaffirmed that the director could continue to have plenary supervision and review authority over patent appeals, specifically all appeals where a decision was rendered that would allow a patent to issue. Doing so would have assured that the director's supervision and review of decisions to issue a patent was so complete as to preclude any possibility of a violation of the Appointments Clause if the members of a patent-only board continued to be appointed by the Secretary of Commerce without Senate confirmation. As for a new patent trial board, it would be adjudicating patent validity claims as between private litigants, where the Patent Office Director need not have any role given the public interest in these proceedings is at best of a secondary nature. For this reason, a new patent trial board under the AIA could have excluded the need for any director oversight of these invalidity trials, instead investing that supervision and review authority in a new presidentially appointed and Senate-confirmed chief administrative trial judge who would lead the new board. Such a structure would have permitted the members of the Patent Trial Board, other than the Senate-confirmed chief judge, to be appointed by the Secretary of Commerce, again without offense to the Appointments Clause. In sum, I believe that there may be policy-driven organizational changes to the current PTAB structure that could represent optimal policy choices for any new legislation that would all but assure Appointments Clause compliance.
Thank you. Now, Mr. Whalen, you may begin.
Chairman Johnson, Ranking Member Roby, Chairman Nadler, and members of the subcommittee, thank you for inviting me here today to discuss the Arthrex decision, the PTAB, and IPRs. I served as a solicitor, as was noted, of the PTO, and I also served as counsel to the Senate Judiciary Committee while the AIA was pending. The Appointments Clause governs the appointment of officers of the United States. Principal officers must be appointed by the President and confirmed by the Senate. Inferior officers may be appointed by the heads of departments. 3 weeks ago, the Federal Circuit held that APJs were unconstitutionally appointed since they are principal officers who must be appointed by the President. To remedy this problem, the court invalidated their civil service protection and made them fireable at will. They demoted them to inferior officers who the Secretary could then appoint. Many questions have arisen. First, does the Appointments Clause problem still exist, given APJs still issue final decisions on behalf of the USPTO? Second, did Arthrex adopt the correct remedy? I question whether Congress would have chosen this remedy, especially given the other remedies available, including second levels of review at places like the ITC and the SEC. The courts could take years to resolve these issues, and in the end, ultimately, may not even have the power to do so. Uncertainty abounds, prompt legislative action may be necessary. At the time, Congress may also wish to consider whether the IPR system is functioning as Congress had originally intended. 8 years have passed, over 10,000 IPRs have been filed, so this may be a good time for Congress to take a second look, as it often does after it's created a new administrative regime. IPRs have had a profound effect on the patent system. However, they received little debate during the AIA as compared to the highly controversial post-grant review second window that ultimately had to be stripped from the bill in order to obtain passage. Yet IPRs share many of the attributes as were feared of PGR second window, including inability to quiet title and multiple and serial petitions. IPRs have devalued every single U.S. patent. Patents are supposed to be presumed valid. They are not before the PTAB. Invalidity must be proven by clear and convincing evidence, not at the PTAB. The numbers confirm this. There are over 1,400 IPRs filed each year. That's 3.5 times as many as the USPTO estimated to Congress. IPR petitioners fare much better than patentees, given IPRs are instituted over 60% of the time, and in final decisions, some claims are invalidated 80% of the times. To my knowledge, no one, or almost no one, thought that there would be 1,400 IPRs per year, that there would be 260 APJs, so many claims would be invalidated, and that the estoppel provision would be so weak. And no one thought that APJs were unconstitutional. But laws can have unexpected and unintended consequences. I want to applaud Director Iancu for several changes he has recently made. However, he alone can only do so much. For the last 8 years, many interested parties have said repeatedly that the system was working just fine. It wasn't, and it still is not. A critical voice seems to have been missing from the discussion, that of the patent owner. Patentees must pay thousands of dollars and wait years to get a patent, and then they must sometimes have to pay hundreds of thousands of dollars and wait years to see if it's valid. I know of no other federal agency where one party may pay thousands of dollars to get a patent or get a grant, and then another party pays the institution to invalidate that grant. But that's what we have today. Something odd is happening at the PTO. Every business day, 1,000 patents issue. But when the PTO reevaluates some of those patents and writes a final decision, it invalidates some claims 80% of the time. It is also amazing to me that the only institution in the United States that does not give PTO credit for its work is the PTO. It can't. Patents are not presumed valid at the PTO. So, as Congress thinks about this, some issues it may wish to consider: presumption of validity, standing, estoppel, and realize that IPRs are often not a substitute for, but are in addition to litigation. And most of all, consider IPRs from the perspective of the patentee. After all, without them, we wouldn't be here. It has been an honor and privilege to appear here today, and I'm at your service. Thank you.
Thank you. And Ms. Wright, you may now begin.
Thank you very much, Chairman Johnson, Chairman Nadler, Vice Chairman Correa, and Ranking Member Roby for inviting me. I'm honored to be here, and I also thank the other distinguished members of the committee. There are a few issues about which I'm more passionate than the PTAB. In that regard, I'll have to limit myself to 5 minutes, but I do want to make one introductory point and then 2 other points. My written testimony lists the empirical and analytical work I have done on the ptah. I've done a number of empirical and analytical studies. Based on this work, I do believe the PTAB is largely functioning as Congress envisioned in the American Invents Act. It is an expert, efficient, and fair alternative to expensive Article III litigation of the validity of issued patents. Second, the Federal Circuit's opinion in Arthrex, though in my view unduly formalist, may represent the views of the current Supreme Court. Third, from the standpoint of sound administrative procedure, the Arthrex remedy is not optimal as a policy matter. I believe it does make the PTAB constitutional, even under the current Supreme Court's jurisprudence, but it is not optimal as a policy matter. As a consequence, Congress could and should cure the problem by enacting a surgical alteration to the patent statute that gives the director a unilateral right of review of PTAB decisions. So let me unpack each of those 3 points. I'll start very quickly with my introductory point. I believe that the data show that not only is PTAB serving the purpose that Congress intended, but this data has been used by the USPTO director to take a number of important steps to make the PTAB function better. For example, the USPTO director used data that my co-authors and I generated on the substitution effects that the PTAB is having to have the PTAB serve as an even more effective substitute for Article III. The director has aligned PTAB's claim construction procedures based upon that data with those used in the Article III courts so that substitution can occur even more efficiently. In addition, the director has implemented procedures to curb serial petitioning and other potential abusive practices. And then finally, and most relevant to the panel today, the director has implemented procedures through which he, working with other senior USPTO personnel, creates precedential opinions that ensure policy consistency across the PTAB. Policy consistency, as we all know, is a very important feature of the administrative state. More specifically, under the procedure the director has created, the director can determine that a particular PTAB opinion may warrant rehearing and convene a precedential opinion panel to determine whether to grant rehearing. By default, this panel consists of the Director, the Commissioner of Patents, and the PTAB Chief. Now, this last change leads directly to the Arthrex opinion. In that opinion, the Federal Circuit panel determined that the creation of this presidential opinion panel was insufficient because the Director is only one member of a three-member panel. In my view, this is probably an unduly formalist reading of what is required for purposes of giving PTAB judges, quote, adequate direction and supervision, unquote, under the Supreme Court's Edmund case. But as Professor Duffy has noted, it may be consistent with what a majority of the current Supreme Court would find. So now to my third point on the issue of remedy. On the positive side, the Arthrex panel's decisions to sever removal protections, I think, is a mechanism for curing the constitutional infirmity. Not only did the intercollegiate decision that Professor Duffy mentioned from the DC Circuit use the same remedy, but it's also consistent with the Supreme Court's decision in Free Enterprise Fund versus PCUB, which also used severance, the severance to deal with an appointments clause challenge. So I think that the remedy is constitutional, but I do think as a policy matter it's a bad idea. Why is it a bad idea? I think it, as Chairman Johnson has mentioned, puts considerable pressure on the policy principle that political review of adjudicators should be transparent. The administrative state generally has such transparent review, whether the administrative adjudication is covered by the APA or whether it's a so-called Type B hearing, as the Administrative Conference of the United States has called these other types of hearings. So if the Congress were so inclined, it could just imitate the other parts of the administrative adjudicatory state that give a politically appointed official a clear right of review. And it would largely replicate the review that's already occurring in the POP panel, but that the current Federal Circuit and maybe the current Supreme Court would think is not sufficiently unilateral. Thank you, and I look forward to your questions.
Thank you. Votes have been called. We have one or perhaps two votes, and the time for voting has expired, but there's still 255 people who have not voted. So we're going to scamper over, do this one vote. Perhaps there will be another vote, which will be 5 minutes after that. So I look forward to us being back here in about 15 minutes. So with that, I'll recess. We are back in session, and I will now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. Ms. Rye, should we assume that the ruling that the ptah violates the appointment clause will stand up on appeal, and if it's and isn't it possible that the courts will work this out themselves?
So it's a very good question, and when you say appeal, I assume you mean not en banc, but appeal to the Supreme Court, or perhaps you mean both. I think on en banc, it may not stand up, and that's, a question that I haven't thought through, with great rigor, but I think on appeal to the Supreme Court, it may well stand up, given Justices Gorsuch, Kavanaugh, Roberts. I'm not as sure about Thomas and Alito, but those three I think are fairly formal when it comes to these questions.
Thank you. I'd like to get the panel's reaction to some potential legislative ideas to address the Appointments Clause problem. Should all ptah judges be appointed by the President and confirmed by the Senate? Should ptah decisions be subject to discretionary review by the Director of the PTO? Or should ptah decisions be reviewable by a special panel of Senate-confirmed ptah judges? Or should ptah decisions be reviewable by the ptah chief judge, which would be made into a Senate-confirmed position? Or should the ptah be divided into two entities, one to hear ex parte proceedings and the other to hear inter partes proceedings? And I'll start with you, Professor Duffy. And your microphone.
I think that the first four of your suggestions all make the final decisions of the PTAB in one way or another reviewable by a Senate-confirmed person. And so I think that all four of those are constitutional. Three of them are expressly the suggestions in my written statement. The fourth one is making the chief judge of the PTAB the person who gets to review, but you'd have to change that person into a Senate-confirmed person. The fifth option, I think, about dividing the court into two parts, I think that's a matter that's sort of sideways to the constitutional issue. The constitutional issue is just making sure that all the decisions are reviewable by somebody who is Senate-confirmed. And I think actually in the opening statements, all the panelists seem to agree that that was the clearest solution, but then there's different examples of that. So from a lawyer's standpoint, I think they're all constitutional. So then I think it's just a matter of policy. I think probably the director review is the easiest one to do. That would not require changing the appointment of any existing officers and just reinstalling a sufficient lever of control. In my written statement, so I would suggest that one.
I agree with Professor Duffy. I would say two things. One, I think it's important to do something quickly, so whatever provides the soonest, best political consensus should be given a priority. Second, I think there is merit to thinking about whether there should be a separate trial-only function in the Patent Office headed by a presidential appointee, because these are private litigants, basically, asking the PTO to adjudicate a private litigation.
Thank you. Mr. Whalen.
Thank you, Mr. Chairman. I think agree with at least some of the people on the panel that director review, simply making that change would be the quickest and most efficient way to probably make it constitutional. And in some ways, to be fair, I think the director has already been trying to do that, although not by himself, through the presidential panel proceedings that he has recently instituted.
All right, thank you. And Ms. Rye?
Yes, I agree that unilateral director review is really just one sentence, maybe in the patent statute, the director shall have a right of review, would be the best option, be surgical, it would be quick, and hopefully not too controversial. And I think it could actually work in tandem with the presidential opinion panel system that's already been set up. And so there wouldn't even be a need to change that system. It would just be on top of that system.
Thank you. Mr. Duffy, do you believe the Arthrex Court's remedy of removing civil service protection for PTAB judges could lead to situations where there are due process concerns? And if yes, can you elaborate?
It is not a great remedy because it says the director can maybe be displeased with the decision and fire this person. So the judge is gone, the judge is gone, but their judgment still is very hard to unwind in a particular case. So it's kind of like the Cheshire cat. The cat's gone, but the smile is still there. And I think that that is not a great remedy. Then you'd also have to say, well, to what extent can people get some sort of process before the director and say this was an incorrect decision? There's no mechanism to try to influence the director's exercise of discretion. So I don't think that, I think many of the members mentioned due process. I think that is in play here, and it does create a sort of difficulty for controlling these judges under the current structure. If I can say one last thing, which is the Chief Justice of the United States in the oil states case actually brought up due process with respect to what's called panel stacking, which is one way that a director might be able to control the judges under the current mechanism. And you can read that portion of the oral argument transcript. I think the Chief Justice was extremely frosty about whether this was constitutional or not. He thought that that was probably not, I think, from his remarks. And so that shows the awkwardness of the current system.
Thank you. I'll now recognize the ranking member for 5 minutes, Ms. Roby.
Thank you, Chairman. So beyond constitutional deficiencies, which I think you all have weighed in very clearly on what your suggestions may be, are there amendments to AIA that Congress should consider to ensure PTAB proceedings are fair for both parties? Anybody? Sure.
So my written testimony talks about this, but I think the two things that Congress should do is it should go back and look at the debate that was going on between the IPR system, as I laid out. There was almost no debate. There was a lot of debate about the PGR second window that was taken out of the bill. And if you see some of the same problems, you could compare and contrast. Are there things that you did not intend to occur that are basically occurring now? But the second, to answer your direct question, the simplest fix, if what we have now is basically a validity challenge, not a re-exam, but a straight-up validity challenge, then make the playing field fair. Presumption of validity, clear and convincing evidence, Phillips, and just make the standards what are in district court, make them the same at the PTA.
That was my second question, so anybody else want to jump in? Do you think, and others can weigh in, do you think that it makes better sense, as was just suggested, to have PTAB apply the same standards district courts apply to find claims invalid in those related proceedings? Sure, please.
Yes, absolutely. We now know from experience that 80% or so of IPR proceedings are actually part of a district court validity challenge to the patent. And it simply makes no sense to give the appearance of unfairness to the patent owner, whether it's unfair or not. If these procedures are actually going to be sustainable and sustained, they need to not only be fair, but have the appearance of fairness, and they won't do that without the clear and convincing evidence standard.
I was about to say, Professor, you look like you want to say something?
Yes, I agree as a policy matter with the argument that claim construction should be the same as between Article 3 and the PTAB, and in fact submitted comments to the PTO and was very pleased that Dr. Iancu decided to go in that direction. I do think as an administrative law professor, it's not, I don't have a huge love of Congress necessarily coming in and micromanaging administrative adjudication. It seems to me that that's the sort of thing that is appropriately delegated to the agency, and it can adapt its adjudicatory practices within the limits of the Constitution to the needs before it. I think having Congress put that into statute would unduly box in the agency.
Should companies be allowed to bring multiple challenges to the same patent, either directly or through a follow-on attack by a surrogate, like the organizations who exist to invalidate patents and who clearly represent the interests of the companies who fund them? Yes.
Two responses to Ms. Rye's point, just a quick response. Congress put preponderance in the statute. Congress has to take it out if they want to change it. As to your second point, estoppel was meant to be real. It was meant to be pick one forum. Don't let some member or organization do it for you. And so I think Congress wanted you to pick. And, you know, clearly when you have laws, people figure out ways around them. You should investigate how they're going around them and put tighter estoppel in. Because I think, as Mr. Armitage said, then you have a fair shot. You pick your shot. And that, to me, would be more balanced.
Anybody else? Well, Mr. Chairman, I would just ask, I mean, there's clearly, you all have provided, both in your written testimony and here today, lots of suggestions, and I would just ask that we continue this conversation as we look to solutions. So I really do appreciate each of you coming here today and offering us very candid testimony from each of you. So thank you so much, and I yield back.
Thank you, and I now recognize the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, and thank you all. Again, we're all saying it, but we appreciate your expertise, and it's a crazy day on Capitol Hill, as you know, so do not interpret the empty seats as a lack of interest. It's just everyone is scattered to the four winds today. So the record of these proceedings, as you know, is really important to us because this is what we go back and study, and the staff and all the members. So I don't want you to think your testimony's in vain. We appreciate you being here. I'm really grateful for the level of attention that's being paid to the Appointments Clause here in the Intellectual Property Subcommittee. And we all recognize, we feel that this subcommittee plays a key role in ensuring the U.S. remains the global leader in innovation, and we all know how important that is. Our country is an exceptional beacon for innovation because our founders took the bold step to enshrine both property rights and guarantee that enforcement of our laws will be done in a manner that's consistent with the underlying principles that govern our republic. I just had two pretty simple questions for you, but trying to summarize this for people who are not deep in the weeds on all the details. But how does the background and the appointment of PTAB APJs different from the selection of ALJs appointed throughout the government? And if you've already answered this, forgive me. I've been in and out like everybody else, but anyone, I guess. Mr. Duffy.
Well, from a constitutional standpoint, I think they are currently now, after the Supreme Court's decision in Lucia from last term, they are now quite similar constitutionally in the sense that administrative law judges generally now or must have the appointment from a head of department. Now, that could be a multi-member commission like the SEC, and the Supreme Court precedent has made that clear, but it has to be an appointment from the head of department. The administrative patent judges have had that since 2008 because I had an article and sort of pointed out that they were not being appointed by a head of department, and the Congress changed that rather quickly to be appointment by the Secretary of Commerce. So in that sense, they're similar. The way they're different is their duties. Their duties are different because the administrative law judges are subject to plenary review, discretionary plenary review in many agencies, but plenary review at the agency head level. So there are Senate-confirmed full officers, non-inferior officers who have the final say, whereas the administrative patent judges and the PTAB that they staff really is not. And there's various ways that people can say, well, the director could influence it this way or that way, but ultimately there's no firm control by any Senate-confirmed officer. So that's the major difference, and that's what's causing the constitutional problem in this case.
Thanks for that.
Can I just make
sure.
one additional point? The statute does provide that the administrative patent judges have to be persons of competent scientific ability and patent ability, which is a a requirement that is not there in the organic statute for many other agencies. And so to the extent we are concerned about expertise, I think it's fair to say that the statute provides for a basic level of expertise.
Well, that actually kind of leads to my next question, and that would be, should Congress amend the statute further, define minimum qualifications to require more than just a technical degree and experience as a patent attorney? And if so, what would that criteria be? What's the ideal? Anybody? Ms. Duffy?
So I think that the Congress could do that if they found that there was a problem already with the hiring practices of the PTO. But I think that if you did want to make that change, you might want to first investigate what the administration is doing in terms of its hiring practices. Usually, this body doesn't legislate unless they think that there is a problem. I think that the administrative patent judges, I think most of them are attorneys. I'd be surprised to find that they are not, or that a large number of them are not. And I think they do try to hire people who have some degree of technical expertise too.
So if it's working well in practice, we don't need to, I mean, I'm not suggesting we should get into the middle of that, but I just wanted to know what you all thought as experts in the field. So.
There actually appears to be very little criticism of the quality of the work because they don't have the legal expertise or the technical expertise to understand what they're doing. So I think this is not a problem in the real world.
Good. Thanks for clarifying that. I will yield back, Mr. Chairman. Thank you for being here.
Thank you. Next, we will hear from the gentleman from Virginia, Mr. Klein, 5 minutes.
Thank you, Mr. Chairman. Thank our witnesses for being here. I want to take issue with the last statement that it seems to be working so well. Isn't it absurd for a federal district court or the federal circuit to issue a decision upholding the validity of a patent only to have the PTAB invalidate the same patent on the grounds similar to those rejected by the courts? Yes.
I think that goes to what was the purpose and how's it working? And I would say yes, but you can get different outcomes, unfortunately, if you have different standards. And so this might be a reason, again, another reason, to align the two standards and not have different outcomes, and essentially make whichever is the first standard, whichever is the first decision, be binding on the second decision.
Well, does the fact that the PTAB invalidated patents upheld by Article III courts demonstrate a lack of oversight authority within the executive branch?
No, not necessarily. I mean, it's a different standard. So if you need to prove clear and convincing evidence and there's a presumption of validity in district court and you can't win, and all you need to do is prove by preponderance of the evidence, which is a lower standard, in theory, they could prove it by 51% and prove invalidity at the PTAB, but not in district court. Whether that makes sense to have that system is a different question.
Okay. Yes, sir.
And I wanted to add that in addition to the difference in burden, in clear and convincing versus preponderance, there's also in the district courts, when validity is challenged, the district court can only determine that the patent is not invalid. The patent adjudication in district court does not determine that the patent is valid. So if another party comes along and challenges the patent in, for example, the PTAB, again, whatever one thinks of, whether it's good as a policy matter, there's nothing illegitimate about another party challenging that patent because it's only been declared not invalid.
So I think that the history here is a little complicated. You first have to go back to talking about the presumption of validity, because you talk about a lack of judicial supervision. What the Congress did in 1952 is codify a presumption of validity that had been built up by case law, but that was a massive shift in power away from the courts to the administrative agency. So my colleagues on the panel have said there's a different standard, and the court is only saying that the patent is not clearly invalid. That actually is a change that occurred in the mid-20th century that shifted power, that aggrandized the power of the administrative agency. So if your concern is the lack of judicial supervision, you might go back and look at why an agency gets to issue a patent oftentimes by just a single examiner, and that actually gets an extraordinary amount of deference from the judiciary, so that they review it under this very deferential standard. And on top of that, from an administrative law standpoint, there is, under current lower court case law, though not Supreme Court case law, there's no judicial review of the administrative action issuing the patent. The Federal Circuit has held there's simply no way to review that. It's outside the Administrative Procedure Act, which is an extraordinary ruling, but nonetheless, that's an enormous amount of administrative power on the front end that you can't forget about if you're trying to get back to first principles and separation of powers. Thank you.
Thank you. Yes?
We talk as if once you're done with the PTAB, the patentee has a valid patent. He doesn't. He just can't have it challenged again under 102 and 103 based on basically the same prior art or something that would have been available. Mm-hmm. When you go to district court, they can still challenge the validity of that same patent based on 101, 112. So it's only a subset that the patentee is now free from challenge in the district court.
Thank you. Mr. Chairman, I yield back.
Thank you. At this time, I'd like to commence a second round of questions. My first will be to the panel, and anyone who wants to respond may. There are a number of competing theories about whether the PTAB is constitutional right now. The government has suggested that the Arthrex decision was effective immediately. Another set of judges suggested that Arthrex should apply retroactively to cure any constitutional defects, yet the mandate in the Arthrex case has not issued. What is your view on this issue, and how disruptive could the Arthrex decision actually be?
So I've thought a lot about this, and I want to begin the statement by saying it's extraordinarily complex, and that's why my written statement and my oral statement talked about uncertainty and about the years that are going to, where the courts are going to have to unwind these things. In terms of the decision, the one theoretical objection to what the Arthrex panel did, which was made by a separate opinion by Judge Dyke, was framed in terms of retroactivity, but it can be framed more clearly, I think, by simply saying that if you go back to Marbury versus Madison, all a court does, courts don't actually strike down statutes. They simply say what the law is. And if the judges cannot constitutionally have tenure, if that actually is the correct view of the Constitution and the laws and the statute, then the judges never did have tenure, because the law never was that way. Even before a court says it's the law, it still was the law. That's the sort of basic, sort of very formalistic view of that judges don't make law. They simply announce what the law is and has always been. That's something Justice Scalia was a very big fan of. Now, that would mean that the judges never had tenure, and therefore, if the removal of their tenure protection solves the constitutional defect, then they never had tenure in the first place. Now, in my written statement, I said it's not clear that that's a sufficient remedy, and I think that the panel here suggested that the only sufficient remedy that is clear is having some sort of Senate-confirmed officer or officers review the decision. But you know, the Arthrex decision has many sub-issues underneath of it, and we will eventually, in a couple years, get a final decision on at least some of them. But that, I don't know if we can wait that long.
Yes.
I would just add, somebody said to me recently, it's interesting, how could the APJs previously had thought they could have been fired at will when they didn't know they could be fired at will and then would have acted differently. So we're acting in an imaginary universe. But I do agree with John that the uncertainty, many people think these decisions are not correct, but talking to constitutional lawyers, administrative colleagues who never talk about patent law, they're talking to me about patent law, they don't even know all the answers and everybody disagrees. So this is going to take at least a year en banc, could be another year at the Supreme Court, and the courts could decide the judges, APJs still have too much authority, still have too much decision-making authority, the director's still not reviewing their work, and it's still unconstitutional unless Congress acts.
Thank you.
One of the last things I do before I go to bed each night is hope that Judge Dyke is correct. Because if we get an en banc ruling that he's correct, nothing bad happens until the Supreme Court does something different, and that gives you all time to have a permanent fix along the lines I think we've been discussing about review and authority.
And in terms of the permanent fix, I do think that a retroactive permanent fix would be useful as well, because I think in creating the certainty we need to make sure that not simply prospectively the director has the right of review, but retroactively the director was deemed to have the right of review.
Thank you. And Professor Rye, would it raise due process concerns if the director uses his new power to remove ptah judges without restriction by firing a judge in the middle of a case for the way the judge was inclined to handle the case?
Yes. It would. Yeah, I think it's certainly in the middle of the case, yes. I think that would be a serious due process issue. Now, the Allapat case was a little bit different, and I'm not sure the Allapat case, which we haven't really talked about, but was a decision from the Federal Circuit, an en banc decision from 1994, where, well, I suppose we have talked about it in that Professor Duffy talked about so-called panel stacking. I'd be reluctant to call it panel stacking. There was a new panel created to rehear the case. I don't think that that's a due process problem, but I do think firing somebody in the middle of his or her deciding a case is a due process problem, yes.
Anyone?
Could APJs currently argue they had something taken away from them by their civil search protection taken away from them, and now they can be fired at will? You know, can they argue that if they're fired for another reason? I mean, and I can't believe, you know, although I don't think Director Iancu is going to start firing people as a practical matter, I can't believe it's a warm and fuzzy feeling to find out one day you were protected by the civil service like everybody else, like I was as a government employee, and then to find out the next day you are not.
I think that there's a constitutional question about the due process, but it's very complex because it would depend on how the director, I think, under the current Federal Circuit ruling, could do that and could fire somebody. As long as the hearing continues, and I think the constitutional due process hearing right would be the basic right from Morgan versus United States, where the court said that he who decides has to be the one who hears. In other words, reads all the documents and has the briefs and everything submitted, has the oral argument if it's statutorily available. That's the person who has to be the decider. That's a crucial feature of administrative due process, and that was established in the first half of the 20th century. So the director could fire somebody. Now, frankly, I don't know how the director would know how somebody's going to rule. Questions at oral argument or something like that, it would be very hard to figure out how the director would figure that out. But if the director did do that, they'd just substitute in a new person, it probably would be constitutional, but it may raise policy concerns, which I think are certainly within the prerogative of the Congress to decide that it is not good policy.
All right.
I think there are really two relevant hypotheticals here. The Patent Office was created largely to decide if patents should issue. So if a patent examiner having a patent application in front of him or her was going to allow a patent issue that the director did not want to issue, it actually wouldn't offend me if the director took that patent application away and explained to the applicant why the patent shouldn't issue. That's fundamentally the director's job, to set policy and understand which patent should and shouldn't issue. On the other hand, if a litigant is in a private litigation in a federal district court, and a federal district court judge is about to rule in favor of one party relative to a patent, the director of the Patent and Trademark Office should not have the ability to have that Article III judge changed because of the way that judge might rule on the patent. So why would it appear fair if instead of having that litigation take place, as it always did before the IPR statute, in the federal district court, we now have the Patent Office conducting that before an administrative patent judge, and the director can say, I don't like the way this private litigation issue may come out, I'm going to put someone else in. I think that's highly offensive, whether it's due process or not, as a technical matter, and does suggest that what the Patent Office does ex parte in deciding if patents should issue should not be the relevant framework for deciding the director's authority in these what otherwise would have been private litigation matters.
Thank you. Ms. Roby?
Well, I just want to talk to you in terms of, the matter at hand really is how this affects companies, so businesses. If it's determined that the fix is not enough, then what happens to the decisions? I mean, can a company rely on the decision? I think this is really the heart of the matter in terms of urgency and the need to take this up, and why today's discussion is so important, but not just ending here today, but moving forward on actually finding what these and putting these solutions into practice. So feel free to comment on that, but I do think it is an important question to ask. Yeah, I mean, both of you can, I've got 4 minutes.
Just quickly, the two things companies that I talk to complain about are uncertainty, and the only thing worse than uncertainty is delayed uncertainty. They need to make decisions. You tell them what the answer is, they can make a decision. They don't know what the answer is, they can't act. A lot of money and time is being spent right now trying to figure this out, and as we've all talked about, the final answer may not be until the Supreme Court, which could take 2 years, and if they don't have the power to solve it, it may not even be done then.
And so I agree with that, and I think that my colleague Bob Armitage said that he'd like that Judge Dyke's solution would work, because at least there wouldn't be a problem for another 2 years until the Supreme Court said something differently. But since a lot of people would think that the Supreme Court might very well say something differently, the problem is still present today. It's not that a sword of Damocles falls, it's that it's hanging there. That's the problem. And I think the sword of Damocles is there, and the uncertainty is there, unless there's some sort of legislative fix. It's not going to come from the courts. It's not going to come from Judge Dyke. It's not going to come from the Arthrex en banc panel. It would only come from the Supreme Court. And for complex reasons, they may not even give a final solution because there are a variety of issues associated with remedy. They usually grant certiorari on one question and limit themselves to that question. And then that can create sub-questions that go back and be litigated for years longer.
And just to complement what John said, or add to it, although Bob may like Judge Dyke to make the en banc decision, he's not going to. There's 12 of them. And if you've looked at their en banc decisions in the last 5 to 10 years, they don't always agree. And sometimes they write lots of different opinions. So you would have a decision, but it would only be until the Supreme Court took it up. And there would be ample, probably dissenting opinions from the Federal Circuit, which essentially are turned into a cert petition to the Supreme Court.
Let me just clarify, if it weren't clear what I hoped I said. I go to bed at night hoping Judge Dyke is right, because he would do retroactively something that during an interim period of time would cause no harm and give the Congress time to act, as Artie Rye says, retroactively to do some good. One of the good things would be to presumably moot the issue so the Supreme Court would actually never have to decide the current issue that we face with the current statute. So it's really the ability of nothing bad to happen before Congress acts. And what do I mean bad? For example, the ptah decisions basically being all of questionable constitutionality. So who knows if decisions invalidating patents really invalidated those patents? I mean, the unthinkable things need to be solved before they become thoughts we all have to live with.
And one last point to add to the chorus that I think is being generated, that it's up to you to do the right thing and fix this. And that is that the due process issue, the one component of it, which is procedural due process, is being litigated right now. And this Arthrex decision makes that procedural due process problem even more complicated, because the question, if, for example, a litigant wanted to say that there's a procedural due process problem with the way that IPRs are working, they could certainly point to the fact that now judges can be fired at will.
Well, again, thank you all for being here. Really appreciate your time today, and thank you, Mr. Chairman. I yield back.
Thank you. With that, we will conclude today's hearing. I want to thank the panelists for their attendance today, and without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned.